Thank you, Madam Chair. Mr. Carlin, I enjoyed very much visiting with you, and as I indicated, if you're confirmed, you're going to be responsible for overseeing a range of government surveillance activities, and to be blunt, you're going to have a lot of cleaning up to do. For years, the Justice Department has allowed the executive branch to rely on a secret body of surveillance law that was inconsistent with the plain meaning of public statutes and the Constitution. This reliance on secret law gave rise to a pervasive culture of information in which senior officials repeatedly made misleading statements to the Congress, the public, and the courts about domestic surveillance. For example, officials from the National Security Division testified on multiple occasions that Section 215 of the Patriot Act was analogous to grand jury subpoena authority, which of course involves individual suspicion. The public can now see that this claim was extraordinarily misleading, and the National Security Division's credibility has been damaged as a result. If you're confirmed to head the National Security Division, what are you going to do to end this culture of misinformation and ensure that statements made to the public, the Congress, and the courts by the department are accurate?
Thank you, Senator. I think it is of the utmost importance, and the attorneys who I've worked with at the National Security Division share this view, that when we testify, whether it's before Congress or provide information to the courts or in other settings, that we do our utmost to provide the full and complete and accurate information. If I may, on the issue that arises in terms of 215 and grand jury subpoenas, it is, of course, in the statute itself, the provision that the records that one can obtain through 215 need to be those records, similar to those records that one could obtain by a grand jury subpoena, as it says in the statute, or other court process. 215 is different than the issuance of a grand jury subpoena, in part because one needs to apply to a judge prior to being able to obtain the authority. And I know that lawyers at the National Security Division and the Department and elsewhere work to make sure that those portions at the time that were classified in terms of the applications of 215 were provided not just to this committee, as would be the normal course of business, but to ensure that that interpretation of the law was made available to all members of the Senate prior to the consideration of the 215. Inclusion, again, I believe it's very important to try to provide as accurate information, as complete as information as possible to this committee and to this body, whether in classified or unclassified form.
If you're confirmed, I hope it will be accurate in the future, because I know when people heard those words, that this was analogous to a grand jury subpoena process, they said, those kinds of processes involve individual suspicion. And frankly, I don't know of any other grand jury subpoenas that allow the government to collect records on this kind of scale. So I'm going to move on. You've indicated that you are going to make a priority ensuring that statements that are made, if you're confirmed, are accurate. In my view, that was not the case in the past. Let me ask you one other question, if I might. As the arguments in favor of bulk phone records collection have been crumbling, executive branch officials most recently have claimed that bulk collection allows the government to review phone records more quickly than would otherwise be possible. One official recently testified that it allows the government to do in minutes what would otherwise take hours. However, the Justice Department Inspector General's January 2010 report on requests for phone records describes an arrangement in which communications companies were able to respond to requests immediately and provide records in a format that could be immediately uploaded onto FBI databases. While the Inspector General found some problems with this particular arrangement, speed was not one of them. In fact, the report goes on to note that the FBI's Counterterrorism Division described this arrangement as providing near real-time servicing of phone record requests. Would it be fair to say that this report, a Justice Department report, indicates that phone companies are actually capable of responding to individual record requests very quickly?
Say this, Senator, not totally familiar with the details of that Inspector General report or whether that arrangement still exists at the FBI, but it has certainly been my experience in the context of some particular cases or investigations that I can recall with a particular telecommunications companies that we have served particular requests on the company, and that they have been able to respond very, very quickly to the FBI, and that speed has been critical in having those national security investigations hold people to account or to prevent future terrorist attacks, and that speed is critical.
Well, I share your view that speed is critical, but what we have is a FBI, in effect, Justice Department Inspector General report indicating that it's possible to get that speed that we need with the kind of approach with respect to phone records without collecting other kinds of processes. And that's my point, is that we're told that without metadata collection, we're not going to get it in a timely way. This report indicates that it is possible to get it in a timely way. Thank you, Madam Chair.
Thank you very much.